Okay, I'm back now. Okay, I'm back, y'all. Rob, what's up, baby? Now I'm gonna finish reading what I was reading earlier. Okay, back to where I was at. Uh, and it says, for approximately, I now practice criminal defense. I have prosecuted hundreds of criminal cases. I have prosecuted defendants in many jury trials of criminal cases ranging from Class B misdemeanor DWI cases to death penalty capital murder cases. I have defended hundreds of clients charged in criminal cases. I have defended clients in many jury trials of criminal cases ranging from Class B misdemeanor DWI cases to capital murder cases. I have been board certified in criminal law since 2018. I have not been the subject of any previous disciplinary order. I have never before been found to have neglected a legal matter entrusted to me or to have handled a matter without adequate preparation. I regularly attend more than the mandatory continuing legal education courses on criminal law topics. I keep up with legislative and case law changes in criminal law. I am a member of associations devoted to the practice of criminal law, including the National Association of Criminal Defense Lawyer, the Texas Criminal Defense Lawyers Association, and the Tarrant County Criminal Defense Lawyers Association, of which I am a current board member. I am also board certified as a criminal trial specialist by the National Board of Trial Advocacy. I represent my clients to the best of my ability. I believe that if I accept employment in the defense of a criminal case, that I owe my client diligent and effective representation. I possess the legal knowledge, skill, and training reasonably necessary to represent clients in criminal cases. To me, diligent and effective representation includes being aware of and preparing to defend against any issue that can arise in a criminal case. I was a member of the defense team for Aaron York Dean in his murder trial that was tried to a jury in November and December of 2022. The other members of the team were my law partner Bob Gill and lead counsel Jim Lane. Mr. Lane unfortunately passed away on the eve of the trial, leaving the defense of the case to Mr. Gill and myself. Mr. Dean is a former Fort Worth police officer and was charged with unaliving Tatiana Jefferson, who was shot in her home on October 12, 2019. From its inception, the case received extensive publicity in the Metroplex. Every facet of the case was covered in detail by the media. The media cover was driven by persons who had an interest in the outcome of a related civil suit. Media coverage from the outset of the case was biased against Mr. Dean. Mr. Dean and his lawyer all received death threats and other personal threats during the time the case was pending, but they never brought any of this proof. They never explained what the threats were, and the only explanation that was written or explained was that license plates were mentioned, and it was a policy violation for the Arlington Police Department because that's where his sister is a cop. She's a Arlington police officer. There were many critical posts made it to social media regarding Mr. Dean and his lawyer. The prosecutor's office also received threats before and during the trial, which they never presented. As an attorney representing a client charged in a high profile case, it was necessary for me to be vigilant as to the effects of the publicity on my client's ability to receive a fair trial in the original venue. Due to the extensive negative media coverage in the Dean case, it was necessary for the defense team to file a motion for a change of venue. There were extensive pretrial hearings conducted on the issue. Every court setting on the case was covered by all local media and attended by persons interested in the civil suit and numerous anti-police protesters and agitators. On several occasions, there were incidents at or near the courthouse on these pretrial hearing dates. Mr. Dean's family and attorney Jim Laren were accused and taunted on one occasion by protesters. Taunted. That's what this is based on. They said things that hurt their feelings. On another occasion in November of 2021, Mr. Dean and lawyer Bob Gill were josted, taunted, and threatened in the courthouse hallway by protesters and agitators, but they never got a video. They never did nothing. During the trial and just prior to the beginning of the defense case, a casket was dropped in the front yard of a defense witness house. She was not a witness. They just did all that so they wouldn't say nothing on the news. Of the city of Fort Worth, the casket bore the name of Atana Jefferson in red paint made to look like blood. On at least one occasion during the trial of the case, co-counsel Bob Gill and I were followed into the courthouse by an individual who had been involved in protest against Mr. Dean and the Fort Worth Police Department. At the time, I recognized this individual from media video as being the leader of anti-police protests in connection with the Aaron Dean case. I came to learn that this individual's name is Anthony Lazon, who is an associate of Mr. Manuel Mata. I have since come to learn that Mata and Lazon hold themselves out to be activists in the field of police accountability. To me, at the time of trial, there were one of the many safety threats. Lazan was present at most of the pretrial hearing. Lazan was present and wore a large bandana covering most of his face while sitting in the gallery during the week-long pretrial hearings moved to the Tom Vandergrill Civil Courts building as a result of the security lapses in the Tim Curry Justice Center that resulted in Attorney Lane and Gill to be pushed around in the hallways. Had nothing to do with us. Both Lazan and Mata were at the courthouse attending the proceeding nearly every day during the trial. They spent most of their time at trial in a neighboring courtroom in which the trial was broadcasted live to accommodate the numerous trial spectators that would not fit in the courtroom where the trial was being held. Mata and Lazan were also observed in the hallway of the courthouse near the door where the trial was being held, speaking to and agitating anti-police crowds that had gathered in the hallway. After the return of the verdict in which Mr. Dean was found guilty of the lesser charge of manslaughter, the court recessed for the day. I came to learn from several sources that there was an incident just outside the courthouse in which Mr. Dean families and supporters were threatened verbally and physically by a large group of protesters and agitators. Dean family and supporters left the area hurriedly to avoid trouble. Some of Mr. Dean's supporters, who included off-duty police officers in civilian clothing, had to later return to the area to retrieve vehicles. The protesters were still in the area. Dean's sister and others were closely followed to their vehicles and heard the agitators call out their license tag numbers. During the incident, those affected were able to clearly see the person involved, but did not know their names at the time. Some of this encounter was streamed on Facebook by Mr. Mata. Teams were concerned for their personal safety. This event was significant to me because it affected the personal safety of persons connected to my client, as well as personal safety of my client, my co-counsel, and myself. Just before testimony in the trial began, the trial court ruled against our motion for change of venue. This meant that the trial would stay in Fort Worth, where the jurors had been exposed to mountains of negative publicity. I knew this would be a potential issue on appeal if Mr. Dean was convicted of any offense, which it wasn't. Accordingly, I made every effort that I could during the trial to make sure the issue was presented for appeal and that the trial court record was complete with every matter that could possibly inform the trial and appellate courts on this issue. To this end, I want to present the testimony of Mr. Mata and Mr. Lazan and build a record of all the activities that have been engaging in to further their goal of influencing the jury and affecting the trial. We had difficulty locating these individuals and getting them into a position where they could be called as witnesses. But we're there every day. But we're in the hallways. We're everywhere. But now y'all have a problem finding us. At one point during the punishment, I was informed that Mr. Mata had made his way into the courtroom where the trial was being held. I learned that Kelsey Crow had seen and positively identified as no, that's not true. See, even in here, he's lying because she never identified me. No one was able to identify me. No one. No one was. And she didn't even know it was me sitting in the court. And that's how fucked up lie this is, right? Threats against Mr. Dean's family and engaging in stalking behavior against some of Mr. Dean's law enforcement supporters that occurred several evenings before. I was further informed that Mata was seated directly behind Mr. Dean's elderly parents as the first break in testimony. But you could sit anywhere in the court, bro. They didn't have it closed off. They didn't have it sectioned off saying private or you couldn't sit here. It was an open place. I could sit wherever I wanted to. I made the strategic decision to place. See, it was him. He keeps saying that he never did anything. He never did anything. I made the strategic decision to place Mr. Mata under oath for the purpose of presenting his testimony at a point in the trial chosen by the trial judge and to move him away from the Dean family. I am also considered the idea of calling Mr. Mata in front of the jury to highlight to the jury the nature of the opposition that the defense trial team experience on a daily basis. But you don't have proof. I observed the judge attempt to place Mata under oath. Mata refused to take the oath and was taken into custody by the trial judge. Later in the day, another judge made the decision to declare Mata's bond insufficient on several criminal cases, which is not true. And I'm fixing to show y'all the proof that it's not true. That it wasn't another judge, it was exactly Judge Gallagher. After further discussion with my client and attorney, the decision was made to not call Mr. Mata as a witness. It was our conclusion that they would not be truthful about their activities and may actually hurt our change of venue chances with their testimony because we're not going to lie for y'all. We're going to tell the truth, and y'all lied all the way. You know what I'm saying? And it was crazy. We abandoned the idea of calling Mata in front of the jury for the same reason. I did not violate Texas disciplinary rule of professional conduct by having them removed from the courtroom. I did not make any false statement to withhold any information. I was simply representing my client in a case where we believed that he was acting in legitimate self-defense in which he faced a potential life sentence. But you didn't act in self-defense. It was proven. Because y'all were at a sentencing. You already found guilty. So the guilty and innocence is done. He was found guilty and we're at the sentencing part. And I didn't I like what it says. This case was not a civil matter, and I did not seek to gain an advantage in any civil matter. That's crazy. I did not work in collusion with Judge Gallagher, and there is no evidence of such. Yes, there is. It's all on your paperwork, bro. They're dumb. I did not. The swearing in of a witness in a trial is a routine matter, except when the person being sworn uses the occasion to create an incident. And that's not what happened. I did not inflict needless harm on these individuals and did not use or threaten to use the criminal process solely to coerce a party in a private matter. But yes, you did. Your statements are saying so, bro. This matter was a very public one. I was not seeking to manipulate the legal system to my personal advantage. I was engaged in defense of my client in a matter in which my client had been could have been sentenced upon to life in prison. Further, I finished say it not. And then he has all these things in here from these people, like the girl. Okay. My name is Tim Gilpin. I am a licensed attorney in good standing with the St. During the month of December, I was employed as an assistant criminal district attorney with the Tarrant County Criminal District Attorney's Office. My office is in Tim Curry Criminal Justice Center, 401 West Belknap. On the morning that the closing arguments for the guilt innocence stage were to be held, I had the opportunity to be walking to work north of Taylor Street towards the Justice Center, which is situated between Taylor Street to east, Belknap Street to the north, Lamar Street to the west, and Weatherford um, Street to the south. I was on the west side of Taylor. While walking to the job, I observed attorney Bob Gill and Miles Brissett appear in the parking lot. I have known whatever. I did not recognize, however, a third person who was in close proximity of both attorneys walking a very short distance behind him. I did not. It did not appear that either attorney was conversing with this third unknown individual, as one might expect. Three people that know each other would would while walking together. That is not true. There was no one else on the street near Gilmer said that necessitated someone being that close to them that was not with them. Both Gilmer were laden down with their briefcase, trial bags, and logbooks. I had heard the possibility that both in Gill, the defendant, and his family had been received. I know that prior to his death at the state of the trial, Dean's lead attorney, Jim, was also receiving threats. I heard that the criminal has been receiving a number of concerning calls regarding the prosecution. The mayor, Matty Parker, had a full-size coffin painted with the name of Tatiana Jefferson and other individuals who had come in contact with police officers dropped off in front of in her front yard for her children to see during the middle of this criminal trial. That's a lie because she wasn't even in Fort Worth. She was on vacation. So it's a lie. All this shit is a lie, dude. And they're willing to lie because they know the judges are going to believe all the bullshit they're talking about. So just know that. That's why I wanted to put this out there. Because they're all full of shit and what they're doing is wrong. And that's it. I just wanted everyone to know that. And you can look it up yourself. You can ask for this. You can request it. You can do all this. You know what I'm saying? So just be vigilant, right? Because what they're doing to us is unlawful and it's illegal and it does not coincide with the Texas Criminal Code of Procedures. They're violating it all the way around by excluding, omitting, and keeping things from being shown to juries and everything. Like they couldn't show Kruger's history of violence. They couldn't bring up the fact that he was fired from Irving Police Department because of the use of force. And they couldn't bring up that he pulled a gun on me at another time because the judge ruled that none of that pertained to what he was being accused of. But that goes all to the character and the fact that he's a liar. So that's what I want you to see. So, so that's all I wanted to say.